You're welcome back. This is NewsFile. It's your most authoritative news analysis platform. And here on NewsFile, we put Ghana first. And we just had our first segment with the Finance Minister, Ken Ofori-Atta, explaining some of the thorny issues that have come up as far as the Agyapa royalties deal is concerned. Now, let's engage with Dr. Tony Obing, founder and president, Africa Institute of Extractive Industries, AIEI. Good morning, and thank you for joining us.
Good morning.
Also joining us via Zoom is Dr. Theo Acheampong, economist and political risk analyst. Doc, thank you for making the time. Eduji Tamaklo, Kujo Tameklo is lawyer and member, NDC National Communications and Legal Team. Thanks for making the time.
Thanks, Samson.
And Dr. Steve Manteao is Chairman Alliance of CSOs working on the extractive, anti-corruption, and good governance. Do we have Steve Manteao on Zoom? Okay. Hopefully he joins us in good time. So let me begin with Theo Acheampong. And you also wrote an article in which you conclude by, appealing to the minister or the government to, as it were, pause on this deal. You have heard the minister. What do you say?
Yeah, good morning once again, and it's always a privilege to be on your platform. I must thank the minister for actually making time to explain some of the thorny issues around the deal. So in the piece that I wrote earlier on within the week, the only reason why I was calling for a pause, that I thought that there were some issues that needed a little bit more clarity, given that some of the other stakeholders, including the civil society organizations, had raised them and answers were not forthcoming. And these were issues around the evaluation, and I'll come to that in a second, the issue around like the governance and the transparency provisions, and then the bigger issue of what I call what we want to do with the mining sector, the bigger transformation agenda. So it was quite good listening to the finance minister a few moments ago as he went through explaining some of the issues that people had raised. But I still think there are some outstanding bits that need to be further interrogated. So basically the purpose for writing that piece was to ask for a pause, to bring more of the stakeholders to the table to discuss them, but also to offer an opportunity to ask what we really want to do with the transformation agenda in the mining sector. And if I can quickly just touch on a bit on the valuation, which I think the minister spent a lot of time also explaining. So the fundamental issue is two things. What you would classify as the book value, which you went at length to explain, and then what is the net asset value. On top of that, you add like the premium or the multiple that you get when you do the valuation. The confusion had been the assignment, if you read the agreement, the section 4.1 of the royalty value, how they couched it as meaning the value of all the future cash flow streams of the respective mines in question. But it wasn't very clear in the agreement that the net asset value is actually different from like the book value. So if we accept that there can be different approaches of calculating the book value, granted, the real question now is what is the underlying net asset value of all the mines that we've got in question, based on which you now go to the market to do an IPO and you get like a multiple on top of that when you benchmark it to Franco-Nevada or other kind of streaming companies in there. That is where I think we need to get a bit more further clarity on, to get an idea of then the guidance that you would want. So you don't want to go to the market, and although we know the market will determine the price, you don't want to go to the market and get something less, So we need to know what we are selling in this new entity or company that we have created, and by offloading 49 or whatever percentage of that. And remember that the value that we're getting, that 500 million, could actually change. So the shareholding can change. it won't necessarily be 49%. You could get 500 million, and based on the value you placed on it, and my own calculation looks for 500 million, we could actually get probably around 20 to 25% of the offload, 20 to 25% of the shareholding. So it really comes down fundamentally to what the net asset value of those assets are, and then on top of that, what the multiple of that will be, as the finance minister explained, and that would lead to bed a lot of the lingering questions or issues that civil society and other organizations raised.
Dr. Acheampong, do I understand you to say that, having listened to the minister, you have revised your call on the government to pause, and that it's okay to proceed?
No, it's not necessarily okay to proceed. I think we need more detail. And in the last segment where you read the Twitter statement, the commenter there actually made the point that I'm trying to raise here, that we need to have more detail on the projections of production from those leases over like the next 30 years.
Right.
And I consider that all you need really is that the first 3 years projection is really the most important. Any other thing beyond that is just a projection. But we need that and some assumptions about gold price, etc., to get an idea of what the fundamental net asset value in question is.
Yeah, right.
If that is provided, and I think the minister has said he's going to get his people to work on that, it would then add a lot more clarity. But the idea, the impression I got from the minister really is that they're going to go ahead with this regardless. So whatever concerns that civil society or other well-meaning individuals have raised practically would, amount to nothing, to use that word advisedly. But it's quite clear that the government is keen on going this direction.
His suggestion is that they are front-loading, all the information that is required, so people will get the information that they need. And you are applauding his response and commitment to publishing a 30-year cash flow.
Yeah, I mean, that's very well what we need. And I must commend the minister for actually, being open about that. It's a dicey one because, again, when you're going to the market, some of these things would count as forward-looking statements, and often you would capture them in the prospectus itself, which would give you an idea of the projections. But even if that wouldn't be made fully available, at least it could still go back to Parliament, who are the sovereign representatives of the people, and that will be kind of a middle-of-the-road approach. But regardless, we need to have an idea of what the net asset value of the mines or the minerals in question is. The idea of listing it and profiting from the upside, based on the multiples, that's not in question for anybody who sort of understands some of these issues.
Right.
The question really is, what are we selling first to the market based on which you expect to, drive or increase the value based on the value of gold prices? And that's where I think, given what the minister said a few moments ago, we must welcome that and wait for those projections to come forward.
What do you make of his response to what many of you have sort of objected to the near lack of control, so to speak, by the state? And you are associated with Imani as well. Imani has suggested that government has given up so much control. By way of my summary, I will show you that the amendment that was done recently to remove the application of the Public Financial Management Act and its regulations, as well as the monitoring and control of the Public Interest and Governance Authority over the SPV, are basically, one, to limit the application of the controlling legislation by removing what you find in these laws as rigorous control by way of financial accountability, good governance checks because the SIGA will be monitoring them, financial reporting and openness to government. It's virtually has also removed the compulsion for disclosures, including the remuneration of the top management of the SPV. It also removes the criminal liability that would have applied for non-compliance with these, legislations in terms of the disclosures and what the law requires. A director could go to prison for 6 to 2 years if they fail to do those things that are required and reported as was required. It has also, by this amendment, removed the regime of what I call the name and shame by the publication in the media of names of violating key officers. If you are an officer of the entity and you were, as it were, not complying with the reporting and disclosure requirements of the law, the law requires that your name could be published in the media for violating the law. And also, it has removed the monitoring by the state's interest and governance, authority entity. Imani's suggestion is that you could keep all of this. You are doing this so that you say you are doing this to list on the London Stock Exchange. Meanwhile, on the London Stock Exchange, they have provided an avenue where the exchange has introduced a sovereign-controlled commercial company option so that the state-owned entities and joint ventures can be listed without their nation state owners losing all control over decision-making. What do you say to his response to this approach? He says what they did is the best.
Yeah, so there are the policy issues which Imani raises, and then there are also the practicalities kind of on the ground. And let me explain that. Basically, you have created an entity that is listed in another jurisdiction. So legally speaking, it's the laws of those jurisdictions, and the lawyers can correct me, that would be applicable for the entity in question here, regardless of who is the majority or minority shareholder.
The relationship agreement says so. It's English law that will govern the relationship.
Exactly. So it then comes to a question of, do the English laws and the provisions within those laws address the concerns around governance, around ownership, around hiring and firing, all those nitty-gritty issues? To a large extent, they do, but that doesn't preclude the fact that by going this route of Jesse via the listing, you've also given away some of the sovereign right. But it's a trade-off, and it's a policy or economic trade-off that needs to be made. The question for me, and the question I think probably we need clarity is, why did they decide, as in the government, to go this route when there were or are other alternatives? And I've heard arguments being made around the tax issues, in the sense that if you were to list or register the company in mainland UK, then you may end up having to pay capital gains or other taxes. So by going the Jesse route, you can avoid that. The complication in there really comes with the extra 49% shareholders, right? So nothing at the moment precludes anyone from creating 10 or 15 shell companies to own or take shares in those entities. And you then have to go beyond the entities to now find out who the true or actual beneficial shareholders are. That's one that has not, as far as I'm concerned, been addressed. But the question of the Ghana governance regime, working SIGA, PFM, etc., as far as this dealing is concerned, and as far as the option that the government has chosen to utilize, it will only matter for the 51% that the state still controls in that entity. That is what it will matter. The other 49%, it won't matter so much. And the wider group or the SPV itself would now be subject to the laws of England and whatever applicable transparency disclosures that need to be made. And, by listing on the LSC, there are also disclosure protocols. There are things that the entities have to go through: annual report, quarterly report, etc., etc. And what then also becomes important then will be the 51% shareholders. The entity in question, the Ghanaian version, would also have to report regularly to the Minister of Finance and the shareholders. So I should be able to go on their website and download the quarterly reports, be able to find out like the share price, the dividend policy, all of those things. I think those issues will be resolved. So I don't really have a fundamental disagreement on that.
And I was actually going to refer you to the law itself for the MIF, Section 36 on good corporate governance. And it says actually that transparency as a fundamental principle. And it says the management of the fund shall be exercised taking into account the overall considerations that minerals income constitute proceeds from the exploitation of non-renewable natural resources, and the overall objective that mineral income and minerals investment income is to be managed for the benefit of the current and future generations of the Republic. The management of and duties associated with the fund shall be carried out in accordance with the highest internationally accepted standards of transparency and good governance. Then it lists several other measures that should ensure this. The question really is very beautiful in the books, but will that happen? Now, let me get to Tony Obing. What would you say, having listened to the minister, on the question of openness, consultation, and also the valuation question and the purpose really of Agyapa?
All right, thanks, Samson, and thank you for having me on your platform. I as you rightly indicated in your introduction, gold, and minerals generally tend to excite our emotions and emotiveness because we believe that gold is really part of our soul as a nation. So anything that you do without gold as a nation would normally attract some public interest, public effort to understand really why you're doing what without gold. And I think that the perception and political economic issues were not addressed properly. And here I'm talking about an economic policy or action that actually has taken away the political side, the perception side. And perceptions are realities if you don't do anything to change that. Now, I was happy that now he admitted to some dearth of consultation, some lack of engagement, which would have made all these things unnecessary if they had been done earlier. And something, imagine that in multimedia, you had everybody, or maybe about 10% or 40% of people called let's say, Ladia Yeneni, John Ladia Yeneni, Isaac Ladia Yeneni over here. Even though multimedia is a private entity, the perception is that why is it that it's only Ladia Yenenis who are working over here? So naturally, people will question why maybe in the structure of this deal, you will have some people who are associated with a particular section. These are perception issues. It doesn't matter whether these people are the best in the world. It doesn't matter these people are the only people you could find, in Ghana. You would still have to deal with that perception. You have to explain. And I think the minister tried to admit that they did not do well in that area. What I thought fell short of his discussions was the fact that, yes, we think that there are issues, we think that there are structural issues, we think there are perception issues, yet we are not going to do anything we'll go ahead with that. I think that defeats the whole purpose of this discussion. He admits, and he in fact throws more light on issues that hitherto appear to be very opaque. Nevertheless, he says we are not going to do anything about that. We will still go ahead. We'll throw the information out. I think that is an area that he needs to really look at very carefully, so that Ghanaians will get a bit more involvement in that because of the nature of our gold. I don't think that, Samson, these NGOs and even the opposition political parties would have come out with all these concerns if, I mean, they did so because they did not like a particular government, or they did not like what is going to happen to this country if the benefit was quite clear. I think it was for the interest of this country that you have all these NGOs coming together to say that there are issues that we need to sit down and address. I haven't heard anyone say that we should not try and maximize the benefit from our royalties. In fact, Samson, as far back as 2013, if you Google, when I was with the Chamber of Mines, we came up with this idea that we should try and form this mining revenue fund, and that should be invested. If you Google, you'll find, I think it was May 2nd, May 2013. And for the same thing, that we would not have to lump all the receipts from the royalties into a consolidated fund. It doesn't give us more. So investing that would be beneficial. And I believe that the previous government had tried something in that direction. So nobody is against getting more for the country. What people have raised concern about is the approach, the involvement of people, the questions of valuation, the maximization of benefit to Ghanaians. So these are areas that I don't think by being indicating that yes, we are going to do it, we're going to, we have listened to you, we are meeting with NGOs, we'll just solve it. You know, I think we need to sit down and then typically address all the sticky issues of valuation, reasonings behind, you know, 1 billion benefit to Ghana, and then mortgaging these royalties, which technically, you know, depends on the price. If the price goes up, Ghana is likely to get more, and if Ghana gets more, what's the implication on that? So I believe the minister did well.
If Ghana gets more, the implication is that we benefit, so we get to do the development we want.
Well, but that should be made clear. You need to.
Is that not clear? That you are a 51% shareholder in the entity?
Yes.
It's not a loan, it's an equity transaction?
Yes, but it should be made clear what we're going to do with the extra revenue that accrues to Ghana. It must be transparent. These are things that, I mean, we have this extractive industries transparency initiative that insists on transparency. So you want to indicate clearly that once we receive the receipts, and I heard him, and I think it was good, I heard him say that we're going to go to the mining sectors, the mining areas to develop, because honestly, one of the characteristic features of mining areas is the lack of infrastructure. The kind of the figure.
So have you heard? If you have followed, they have said that mining infrastructure, I think there's some 10% somewhere that is going to be used for these purposes. The deputy minister have explained all of these. So at least, are we not able to admit that for the first time, we are not going to have our mineral royalties come in, dump in the consolidated fund, and they vanish? As in, they get diluted, we don't know what exactly they are used for. But now, they have been segregated, and they are going to be watched. And in addition to that, we don't just take the money and use it. We are going to take the money and try to multiply, invest the money. What else could we be asking for?
Look, as I've said, no one is against the efforts by any government to try and multiply or even quadruplicate the benefit from the receipt of royalties. There's no doubt about that. I think the concern has been whether is receiving the maximum value for the receipt from our royalties. Whether we have adopted an approach that is transparent enough, because everybody's interested. If it was maybe Tony Obin Company Limited, nobody cares. It's me. If I invest and I get higher returns, that's fine. But it's for Ghana. It's a country, and so people are going to be interested. The citizens are going to be interested in what is it likely that we're going to get. And I've heard people asking rather correctly for the cash flow, the projected cash flows, which will indicate to us that, look, once we have done this, these are the likely returns that we're going to get. And then we have clear earmarked areas where these resources, the extra resources that will come, will go into.
Yeah, so we are being told about all of these. So tell me, what is your level of satisfaction with this whole process? And what is your level of dissatisfaction? In percentage terms, 100%.
Yes, I am well. Let me explain my level of, before I bring you the percentage. It was difficult to give a percentage. My level of satisfaction is the fact that we are not going to throw all the receipt, the mineral royalty receipt, into consolidated fund. We get much less from it. So the idea that we are going to find a way to get more is very good. It's very, very satisfying. And of course, the fact that the perception issues, which have been, because they are very important. When you are managing an economy, when you're managing people, you want to be sure that you go along with them. Now, the minister admits that there were some perception deficit, consultation deficit, engagement deficit. So they are going to address that. So they constitute my satisfaction. So I'll give it maybe 47% or something, and then the remaining 63 we need to resolve. We need to resolve that.
Okay. Godwin.
Senior. Yes.
You listened to the minister.
Yes.
And the questions of transparency, openness, reverse what has been said to be opaque. His response, the question of valuation, the questions of losing control. What do you say to the explanations he has given?
Yes, something. I think it's important that this point is made, that in the passage of the Mineral Income Investment Fund, that's Act 978, the NDC minority, there was a certain unanimity in the passage.
Okay.
Because we believe in principle the question of maximizing the benefits accruing to the state from our mineral income and the associated taxes and royalties. Now, listening to the minister, and like I usually do, a person who is conflicted, I don't usually give any weight to what he says. Because our Minister of Finance, and what he failed to disclose on this panel, is that a company that he has beneficial interest in, Data Bank, is directly involved in this transaction. Now, when you have a situation where...
that information is from where?
No. I mean, take all the documentations.
Which of them? If you can point me to a specific documentation where Data Bank is named as being part of this transaction, as what? As what, consultants, or what are they?
Several transaction advisors had been recruited for this transaction. Minister Ken Oforiatta had spoken. In fact, on Peace FM, he himself admitted that a company that he has interest, which is Data Bank, is involved, except to say that the selection of Data Bank was done on merit. So it is an admitted fact. There's no point believing.
Okay.
And so the point I'm making
because I didn't have the opportunity of listening to
No, I mean this.
Yes, I just wanted
your platform. Your platform is a very credible platform.
Okay, go ahead.
And it can be fast-checked easily. He made a point clearly that as far as he is concerned, the selection of Data Bank was done on merit. And I'm saying that once someone's financial interests are involved in a transaction, his defense cannot be deemed to be one motivated by the national interest, especially when he has a proprietary interest. And you and I, if we appear before a judge, and the judge has a scintilla of interest in the matter you and I are involved in, the first thing that we'll do is that we'll ask him to recuse himself. That's an admitted fact. And so when you have our Minister of Finance having his company or a company that he has beneficial interest involved in a transaction of this nature, the defense he puts forward, I will not even buy it for anything. He is conflicted. And it's important that he discloses the nature of his interest before we even proceed with this transaction. And look, Senior, you will note that this was the executive approval.
This is something you are introducing, which is not something he responded to here. You are
no. I'm saying that all of the responses that he had been given or he had given today, if you discount the nature of his interests in this whole transaction, you put less weight on what he has said. And I'm saying that, look, if you look at the executive approval given to this transaction on the 24th day of March 2020, with reference number OPS 182 volume 9, 2020, and signed by no other person but Nana Asante Bediatu, Secretary to the President, you will notice that even when the request was made to give presidential blessings to enable the amendment to the Act 978, what we have all not asked ourselves, and the minister did not address, is that at the time Parliament passed this particular, amendment, the amendment was supposed to be the basis, the legal authorization in order to operationalize all of these agreements that we have. Even before President Nana Addo Dankwa Akufo-Addo will give presidential assent to the amendment that will provide the legal backing to operationalize all of these special purpose vehicles we are talking about. The transaction had already happened. And you and I, if we are given the opportunity in court to say that we have operationalized a transaction and the law that will allow you to do that had not even come to place, the first thing that you raise will be the authority of Mark 4 and USC and tell me that you cannot put something on nothing and expect it to stand. The point I'm making is that if you look at this particular transaction, the indecent haste with which all of this thing was put together, and the obvious lack of transparency, the obvious cases of conflict of interest, persons directly associated with our president, all involved in putting up this transaction together, and the legal opinion proffered by the learned Attorney General 22nd July and the 12th of August, when you put all of this thing together, the position the minority and the NDC has taken that this transaction ought to be cancelled immediately still stands. And today, lo and behold,
it ought to be cancelled because of what?
First of all, like he said, matters involving royalties, minerals, comes with its own associated emotional and sentimental issues. And so, in seeking how to use them, you need what is called broader consultation. The minister admits that that was not done. Two, you are aware that the CSOs, in their initial and preliminary commentary, came to the conclusion that when you put all of these things together, what you see is what is called elite capture. The position advanced by the CSO is a position that quite clearly, when you put all of these individuals, and look.
Are you aware the person who used the expression elite capture has withdrawn that?
No, he has not. Yeah. In fact, what he said, subsequent interview, which is Steve Mantia, was to say that in a different interview, he was asked these two parties, which one, blah, 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 blah. And he said, no, the 2020 election is going to be a thief and arm robber. That is what he has withdrawn. The question of this whole transaction demonstrating elite capture still stands. And in fact, it was a position advanced by no less than 15 CSOs. But you see, Sina, just 1 minute so that I can. Look, if you pick the Attorney General's legal opinion, on the 12th of August, I think I have it here. I want to just read something. And I saw the last time there was this one, the 12th August opinion. All the issues raised, principally in the 22nd July matters, Do you know that the final agreement that was passed by Parliament, most of them were maintained?
Can you show us?
For example, if you pick the question of the entire agreement appear not to have a terminal duration, it still stands. It has not been changed. If you and I, we are consulted to draft an agreement, and the agreement basically runs in perpetuity, the first thing that you say is that no, this agreement has a problem. And when you are dealing with mineral royalties that goes directly to people, you should be a bit more cautious. Even more important, Senior, I've heard this conversation.
I have heard this kind of debate, and I think the useful thing to do is that you hold the agreement and point to what the Attorney General said, redraft, and show how it has not been redrafted. Point to what the Attorney General says, remove, and show where it has not been removed. But when you make a general
no, it's not a general statement.
that there are things that the Attorney General asks that are still
been very
in the
specific.
final,
I've been
in
specific.
the final document.
No,
without showing, I think we cannot do that on this desk.
No, the agreement itself is 140 pages. So to expect me to carry 140-page document here will be grossly unfair. In fact, when the minister came here and spoke, he never showed it. But I'm not even... The point I'm making to you, Samson, permit me to answer your question.
You are referring to
you want
the
your
amended
platform.
agreement.
I am saying that, for
you are referring to the amended agreement, not so.
You wait, Samson.
Let's do it this
22nd July, this is it. You
are referring to the amended agreement.
Fantastic, fantastic.
Great, I have a copy here. So point to what the Attorney General said. The 7 things that she says were outstanding before the agreement hit Parliament. She wrote on the 12th, and on the 13th, the agreement got to Parliament. So, can you point out that any of the 7 things she says were outstanding?
Now, and then, can I proceed?
And then we can go to the document. I have it here.
At page 2.
Page 2 of which?
Of the 22nd July letter.
22nd July.
Of the Attorney General's opinion.
Okay.
Are you there?
You go ahead.
This is what the Attorney General says.
Page 2.
Further, it is noted that the terms and conditions of the agreement are very onerous.
That's paragraph 3.
That is so. Point 4. The provisions are skewed against the interests of the fund and the Republic. Both the fund and the Republic have strict obligations and liabilities with punitive consequences. In the event of a breach or default, whilst the other contracting parties, namely Royal Co, LateCo, are to use their best efforts to ensure the execution
of the transaction.
Then we proceed. The agreement ran in perpetuity and therefore has no face term. Is it there?
Go ahead.
In the agreement as passed by Parliament, tell me the fixed term. You have it. Tell me the fixed term of the agreement.
In the agreement,
government communicators have indicated that the agreement is for 15 years. That's incorrect. Because the nature of the agreement and how it is structured, a renewal of the mining lease, the agreement continues without renewal. And so, the explanation offered is that no, let's allow it to run. But it was not changed in the agreement passed by the Parliament of the Republic of Ghana. Because the agreement is coterminous with the mining leases, so renewed. That's a fact.
This is what you have in the agreement. Section 2.1, effective date. The provisions of this agreement shall only commence when the last of the following conditions has been satisfied. Okay, is that what? The term, section 2.2. This agreement and any assignment and allocation of gold mineral royalties under it shall terminate on the date on which the last of the allocated mining leases has expired or has been terminated without any further extension or renewal. Such period, the term, the Republic may, in its sole discretion, extend the term of this agreement.
So what's the point? So what's the point? I am saying that it is this particular thing
so now
that the learned Attorney General said.
Now read the Attorney General's 12 August advice.
I have it here as well.
Yes, 12 August advice.
This is it.
Yes.
Do you have the same thing?
Yeah, I have 12 August advice. Yes.
So the Attorney General then proceeds to say that we have reviewed the latest letter and the reference and submitted, and note our comments have been incorporated and changes effected to the except. And then the Attorney General
that she provides does not include this.
No, the point I'm making is that, and I have listened to the persons who advised the Republic on this, and they say that they did not change because they provided an explanation why it ought to be maintained. It is not because they changed it. Okay. So we need to be clear. Remember that Gabi...
what is wrong with that? If you are giving legal advice, you and I are in practice.
Yes.
You give advice on things that you don't have expertise in.
Please.
Wait,
say, I think that is demeaning. That is demeaning.
You know the law.
No, with the greatest respect. I'm
not referring to you.
No,
I'm talking
not
about...
me. No. The point I'm saying is that
let me ask you the question.
Our Attorney General provides a legal opinion. You are not the first person who is making that point. I have listened to key government spokespersons say that the Attorney General, as at the time she proffered the 22nd July, did not understand the nature of the transaction. I mean, what in God's name will cause you to make that statement? Because you see, at the Attorney General Department, there are persons with varied expertise.
Exactly.
And so when they put an opinion together, it is not an opinion of one person hiding in a corner. So the suggestion that the opinion coming from them is coming from a person who has a demonstrable lack of knowledge of the transaction. It's not helpful. Let's not entertain it.
Don't you go to court?
Let's not entertain it.
Can we not have a... Don't you go to court on a matter that you have a solid case, not on the basis of your expertise in that area, but you have listened to experts and framed the case properly for them? Don't you do that?
Well, Senior, here is the question.
Don't you do that?
There's no evidence here that the time the respected Attorney General put this opinion together, she had a certain demonstrable lack of knowledge in the transaction.
The Attorney General now tells you on the 12th.
And her conclusion is that we have no further comment.
Now listen.
This is her conclusion.
She says that we have reviewed the latest letter and the reference and the submitted draft agreements, and note that our comments have been incorporated and changes effected to the draft agreement except the following. And in the following, she doesn't tell you that she has an issue with the term.
And I have told you that this transaction, the likes of Gabi have spoken to it, other persons have communicated relative to it. I have listened to the chairman of MIS, I've listened to a member of the finance committee, Agyapa Deal. Several persons have spoken to this transaction. So it is not as though this is one-line communication relative to this transaction. But even the same opinion that you are reading, the last portion, very instructive. We have no further comment on the draft agreement. The agreement may therefore be executed subject to the above comment. As you speak, as the host of NewsFile, are you aware that at the time the representatives of our people finally passed this on the 14th, all these matters were incorporated?
All which matters?
The matters, even the outstanding matter that she says that her whatever it is subject to, has it been incorporated?
If your question is to me, I have read the final agreement, and I can't see that they have not been incorporated. That's why I say I'm better off if you can point me to specifically where in the agreement something has not been done.
Samson, I gave you a classic example, even the one involving the duration. You are saying that it is still there. Have you seen the original agreement? The same provision. All they did was to provide an explanation why they had to.
Did she say here that they should change that term?
She raised,
is it not the latest? Is it not the latest?
I think that Samson,
or the
principal legal advisor to the Republic had the benefit of looking at an agreement. And in her opinion, the agreement runs in perpetuity. And this is what she said. But just to make this point, Samson, all of these matters we are having a discussion about goes to the very question of the sovereignty of this republic. Like I told you, matters that involve mineral royalties are very germane. In some jurisdictions, matters involving how minerals and others are distributed have become the source of conflict. The Niger Delta incidents, among all other things. As we speak, the minister made a point that, look, under the myth, you are supposed to have the Mineral Income Development Fund. The fund is supposed to allocate 20% to communities affected directly by mining. Question, has that been done? So that if today there is a conversation national that 75.6% of our overall royalties are going to be given to an entity, and that entity is going to give further to another entity, and government of Ghana will be retaining a certain percentage, and the people do not even know as we speak what is the actual value of this particular transaction that we are talking about. First question, what informed the representatives of our people, that is parliament, the majority, in this case let the point be made clear that the minority stage a walkout, so the MPP majority, what informed their decision to pass it? Something you and I know, and I'm never opposed to using resources either for collateral or what have you. Because when President Kufuor decided to build Bui Dam, he used part of our cocoa proceeds to do that. When we decided to build a gas infrastructure in the Trouble, we used part of our oil proceeds. Today, as we speak, can we tell, you are a very respected journalist, can you tell us what exactly are we going to use the front load $500 million to do? Can you tell me?
It's a question of whether you believe or trust what the government is saying.
When Parliament passed the agreement, Parliament and the agreement, you have it. When they went, the relationship, the indemnity clauses, the agreement itself, the assignment agreement. Can you specifically tell the people of this country watching us, what would this government use the $500 million for? You
are saying that you expect that to be in this agreement?
That's what I told you.
No, you know it cannot be in this agreement. So
when we use the Sino-Hydro, Parliament was given...
No, the agreements that have been passed are not agreements that should contain what the money is to be used for.
That is why I'm saying that. No, that is why I'm saying that. In the spirit that inform what happened with our resources relative to the gas project. And remember the gas project, Parliament gave the approval directly that use it for this particular thing. 12 landing beaches, among other things. In this particular case, do we know as a people what we'll be using the money for? Yes.
So that is a legitimate question to ask, and everybody has asked that question. You have heard the responses from the deputy minister. You have heard the responses from the minister.
They give vague answers.
You are not satisfied with the response.
No,
is that the case?
No, they give vague answers.
Okay, so they are giving you answers.
No, they say infrastructure project. Okay. I'm saying that similar transactions.
But I need you to tell me that the Minerals Royalties Investment Agreement, the Relationship Agreement, the Mineral Revenue Management Agreement, the Operation Management Agreement, and the Assignment Agreement. You have referred also to the Indemnity Deed and the rest of them. You are saying you expected what the money will be channeled into and what the investments that will come, the 51% that government will hold, the specific projects they will go into to be in any of these documents. You still insist?
What I have indicated that at the time Parliament of Ghana approved all of this transaction, we ought to know that this is not money that will come. We'll put back into the consolidated fund. The very reason why we decided to create the myth is that we'll have a dedicated fund that will manage our mineral royalties. So if you go and bring the money, Samson, and the money gets it back into the consolidated fund, used to pay salaries. I'm just saying.
It won't go to consolidated fund.
No, you cannot.
If you read the processes, it doesn't go to the consolidated fund.
What you are not getting is that if the 500 million at the end of the day, we get it. The minister...
It doesn't go to consolidated fund.
You are not getting my point. What I'm saying is that Minister Keno Foriata, if he's the minister of Finance, now up to when this money will be realized, has the discretion to decide. And I'm saying that where you have specific project tied.
No, he doesn't have the discretion to decide, because the fund, the law setting up the fund, gives the fund the power as to how to invest the money and how to use it.
And when you speak to government communicators, all they say is that the money will be used for infrastructure development without more. And I'm asking you that with the people watching us today, tomorrow, if this money comes and minister decides A, B, C, D is what I intend, or the fund, or its governing trustees decide that this is what we intend to use the fund for,
okay,
can you stop them?
I think now you are clear on it, that
yes,
if the fund decides what it has to be used.
Yes, but I'm saying that, fund, you see, but I'm saying that, something.
And the fund belongs to government.
All funds belongs to government.
No, the fund we are talking about here.
It's government of Ghana.
Belongs to government.
Government of Ghana.
And
100% sharehold.
Correct. So if they say it will be used for projects A, B, C, what is your distrust about the fund being able to utilize it?
I just made a point right now. That, for instance, when we put up GET Fund, we said for educational infrastructure and other related educational matters. When we put together ESLA, it was to retire funds coming from or associated legacy debts, among other things. So if tomorrow, government of Ghana proceeds from ESLA, you use it to pay pensions, quite clearly, would you be working within the terms? And so these are the issues that we are raising. That
is it right to compare loans, okay, loan arrangements to an equity arrangement where we set up a company that we own?
Let us not confuse our people. As we speak, government of Ghana, for instance, had used GET Fund proceeds to go for 1.5 billion, okay, and the money is to be used for infrastructure projects within the educational sector. Do you get my point? So let the impression not be created as though this is something novel.
No, this is novel. This is not a loan transaction.
I'm not saying,
an equity transaction.
I'm not saying that it is a loan transaction. But remember that
the matters you have referred to, the NDC also complains that the government has mortgaged the GET Fund receivables.
Which is true.
For a particular purpose. So that's what you are referring to.
Yes.
They have mortgaged the
ESLA.
energy sector levies for a particular purpose. And that's what they are using them for.
Bauxite as well for Sino-Hydro.
Of course, we know specifically what is going to. These are, and the road fund. So we are talking about loan arrangements which are supposed to...
Something. When the Sino-Hydro transaction came, and the NDC raised the question that this so-called barter arrangement, in fact, is a loan, for which we even complained to the IMF and the World Bank, that the amount should add up to our public debt. That conversation was discussed on this very platform. They said, no, it was not a loan, it was a unique. But at the end of the day, we still aim to get to pay whatever it is. It is the state that is responsible for it.
At the end of the day, was it adjudged to be a loan? You went to the World Bank to find out whether it would be a loan.
No, but you were raising the issue of loan and equity. And I'm saying that this is just worse.
Okay.
In fact, all we are doing is to raise funds for projects.
They are seeking to raise non-debt funds. That's what they are doing.
And you know why? It's a simple thing. We have borrowed so much that now we want vehicles that we can use to offload the public debt,
the discussion,
so that the debt of our public will be lower.
We haven't forgotten that you are there, and Dr. Mantea, we haven't forgotten that you're also supposed to be on the line. We'll be right back.